good evening and welcome to the Lifeline on Equa TV Africa. Today is an interesting day and we are discussing the topic land administration. We started the discussion last week and we'll go on with it today as we try to round up. My name is Victoria Yemisi Olanio, and with me in the studio to discuss this topic is Barrister Izangawari. You're welcome.
Thank you, Victoria. Good evening, viewers.
You're welcome. And we have Barrister Stephen Ahilitu with us on the show. You're welcome.
Thank you, Vicky. Good evening, viewers.
Okay, last week we'll just do a bit of recap of what we dealt with last week. We dealt with land administration, and we realized that land is a natural blessing from God, and God has given it to each and every one of us, and the state government has been given, the various state governments have been given the right to govern and administer the land in their territory, but they hold this land in trust for the citizens of the people and the people in general. Okay, so we also talked about land ownership, who can own land, and we said anybody can own land as long as you have the capacity to acquire it. And even for infants who do not have, or minors in the, excuse my terms, a minor can also acquire land, and through his guardian or an older person in his name. So we have the opportunity to acquire land. And today we will go further on the discussion, and this evening we want to touch on certain areas which might be new, which we didn't discuss last week. Just to remind us that this is a call-in show, so at 6:30 the phone lines will be open and you can call in to make your comments and contribution. The phone lines will be, the number will be beamed on the TV set. Barrister Izangawari, we said that ownership could be obtained, by C of O. So how does an individual obtain a C of O from the state government of within their jurisdiction?
Thank you very much, Victoria. The processes for getting a C of O, let me say they are in two categories.
Okay.
The first one is the customary right of occupancy, which is given by the local government, lands department.
Okay.
That one is usually given to people who have applied to the local government registry in their respective localities,
Okay.
particularly in rural areas.
All right.
And so there are two ways of doing it. The first one is for the applicant who owns customary land to approach the local government with proof that he is the owner of that land.
Okay.
How do you get to know that the local government will have to liaise with the traditional rulers of that area to prove that this person who has applied to the local government that he is the owner of this land, who is seeking to get customary right of occupancy,
Okay.
is the true owner. And then he will sign the necessary forms obtained from the local government lands department, and this is done, and a surveyor is sent to the land from the local government lands registry to go and conduct a survey of the land to ascertain, because a statutory right of occupancy or a customary right of occupancy cannot be given until there's a ascertainment of the land,
Okay.
as to what is the demarcation, the dimension of the land. So that will take place. So the survey will be conducted and it will be registered in the lands department of the local government, and that will be done.
Okay.
So it also follows for people who have done land transaction in the local government, like somebody who buys land in rural areas and in the rural area, and he wants the land to be registered.
Yeah.
He will also get his land transaction agreement that he has done with the customary owner of the land,
Okay.
to take it to the local government as a proof that he has purchased or he has acquired this land from the customary owner. Then the customary owner with him will have signed this agreement. They will still conduct inspection on the land, survey the land, know the dimensions of the land. Then the application for grant of statutory right of occupancy, customary right of occupancy will be now issued to the person. That is in the local government.
Okay.
Now, coming to the statutory right of occupancy, that one is done at the land registry of the state. So, in that land registry, the person who has acquired land from another will take it with a proof of ownership.
Okay.
And how do you get a proof of ownership? Proof of ownership is you go to the land department of the local government, do a change of ownership
Okay.
with the person who has sold to the new owner who has acquired, either from a customary owner or who has acquired from somebody who did not at all carried out the processes of registration.
Okay.
So if that happens, then you now go and do change of ownership at the local government. There will have to be a survey plan attached to the form for change of ownership.
Okay.
The dimensions of the land will be defined. Who is selling to who will be defined. The rate at which it was sold will be defined. And then the local government charges a certain percentage, mostly in this climb. Is 3% they charge of the consideration for the land. Then you pay some inspection fee to the local government, who will take its own officers there. They will inspect the land, take note of all the coordinates of the land, and then a change of ownership is issued.
All right.
After that, then your person now comes to the land registry of the state, which in most cases in our various states here is at the Ministry of Land Survey and Town Planning of the various states. So the person now acquires the application form for CFO.
Okay.
In most cases, in the previous regimes before the introduction of the Geographic Information System, it was formed for right of occupancy, RFO.
Okay.
But in most jurisdictions now, they will quickly just process the certificate of occupancy instead of doing it in piecemeal.
Yes.
To give a right of occupancy first before giving the certificate of occupancy. So now, most of it is to go straight to filling the form for for certificate of occupancy.
Okay.
So you go to the land registry, you pick the necessary forms, and then you fill them. In most cases, in most lands department, they will ask for the applicant to bring tax clearance to be sure that he is a responsible citizen. He has been paying his taxes. He has no default. So they will ask him to bring his tax clearance certificate to attach to the application form that he has made to the lands registry. And then it will now follow all the necessary procedure. The fact that a surveyor has made a survey plan does not end there. They have a survey department in every land registry. The survey department will still go to the land and plot all the charts and ensure that the coordinates as contained on the survey plan presented by the applicant are accurate. And there are no issues, no overlapping to another person's land, no, because if you do that, there will be problems. So they will go there, carry out their survey again, ensure that everything as presented by the applicant is correct. And thereafter, they will now issue a certificate of occupancy. Or in some other claims, they will issue right of occupancy first before the certificate will now be issued. But upon that, the applicant, if he has been issued with that certificate, he will start paying ground rent
Okay.
because he has now become a tenant of the state. The state is now administering that land on behalf of the citizens. So the state has now allocated the land to him
Okay.
as a tenant of the state. So he now pays rent. And that is one of the ways that government generates revenue and to continue developing the state. So these are, in a nutshell, the processes you can follow. Any individual who is interested in getting a certificate of occupancy should follow and get it.
Okay. Barrister Ahili, let me just find out, does this process entail you getting a lawyer, or you can go ahead as an individual, just walk straight to the land registry and do it?
Well, it depends on the person's choice.
Okay.
The person may process it by himself or by herself. It does not stop anyone from processing the right of occupancy in person. However, it is also open to the person to use a legal practitioner to process the right of occupancy, or some other estate valuer to carry out the process for him.
Okay. All right. Thank you.
By the way, a person can do by another what he can do by himself. So you could do it personally or by a legal practitioner.
Okay. Just to make our viewers know what they can do and what they should also engage a legal practitioner to do. But I will advise there are certain technicalities which I know it's only a legal practitioner that might be aware of that, and would also ease the procedure for you. To ask, is there a difference between the customary right of occupancy and the statutory right of occupancy? We know Barrister Izangawari elaborated on two types of rights of occupancy that a person can obtain. So is there a difference, or if I have a customary right of occupancy, I'm home and dry?
Yeah, there's a difference. The customary right of occupancy is recognized by, is granted by the local government, and it has its own limitation.
Okay.
When someone has, it has its own limitations. Why, as he has mentioned earlier, the statutory right of occupancy is granted by the state governor.
Okay.
Or it may be the State Commissioner for Lands and Survey, or Permanent Secretary, but signing on behalf of the governor. So it has a wider reach, and then even the term of grant for statutory right of occupancy is longer years as compared to that of the customary right of occupancy.
Okay.
And then, land is one of the most valuable possessions that one could have, and it keeps appreciating in value, and it can also be used for accessing as security for accessing some
loans or facilities.
Or credit facility. Some banks will not accept the customary right of occupancy, but there's no bank or no institution that will reject the statutory right of occupancy.
Okay.
So the advantage is that it has a wider acceptability as compared to the customary right of occupancy.
Okay. Okay. Barrister Awari, just to ask, can I convert a customary right of occupancy to a statutory right of occupancy, or I should just, once it's in a rural area, I should just leave it hanging like that?
No, I think my co-discussant, Barrister Hiller, has hit the nail on the head. Just to add to it, on the differences between the customary right of occupancy and the statutory right. He mentioned the terms. Mostly, you will find out that in customary right of occupancy, the term may not exceed 30 years. But for statutory right of occupancy, it is always 99 years.
Okay. Okay.
So, so he has made the point, just to elaborate. Now, whether it is possible to convert the customary right of occupancy to a statutory right of occupancy,
Yes.
it is.
Okay.
It is. If anybody has already secured a customary right of occupancy, it is even easier at that stage to convert it to a statutory right of occupancy.
Okay.
What he will need to do is to come with that proof to the state land registry and pick the necessary forms and pay the prescribed fees and come with his tax clearance in most jurisdictions that is required to show that he is truly a responsible citizen of his place or of his country, so that the procedure continues from that point. So he will not have to start like someone who has gone to who is coming now to register the land afresh. He will continue from where he has stopped. So it's easier even at that stage.
Okay.
Yes.
In other words, there has to be a foundation
Yes.
on which a statutory right of occupancy will rest.
Okay.
So where there is a customary right of occupancy, the foundation has already been laid. It is easier then to build on.
Yes.
Thank you very much. To also ask Barrister Ahile, for if you have a COO over a property, do I just, if I want to transfer the title to another person, do I just sell the land, or is there any procedure, or is it different from somebody who does not have a title over the land, to sell, and the person who has a title? What is there a difference, or I can just go ahead and transfer?
Well, let me say registered title.
Okay.
Because even the person who does not have a right of occupancy, if the land is his own, maybe he inherited from his forefathers, then he has a title.
All right.
In fact, he has a deemed
Title.
right of occupancy.
Oh, okay.
If the law deems that he has a right of occupancy over that land, and so that is why he can sell it. If it were that he does not have title, he cannot even sell, because the legal principle is namuda quod non habet, which means you cannot give what you do not have.
Yes.
So if you do not have title, you cannot sell. But what we are talking about is registered title.
All right.
Yes. The difference is there's a world of difference between an unregistered title and a registered title.
Okay.
For the unregistered title, the most important thing is the 3 P's. The parties, the property, and the price.
Okay.
So if these 3 things are there, a transaction will validly take place. The parties, Victoria is selling a piece of land to Awari. They are the parties. What is this piece of land? How large is it? 100 by 100, located between Ministry of Lands, Plateau State, and Eco Headquarters, Jos. The land is located there 100 by 100 feet.
Okay.
That is the property.
Okay.
The price, how much is the price? 5 million naira. That settles it. If this is done and there are witnesses that can attest that this transaction took place, it is valid and is standing, even if it is not written.
Okay.
By the way, coming from a background of not knowing how to read and write, I don't want to say illiteracy, because it doesn't necessarily mean you must read and write English to be literate. So once that is done, and witnesses can say, yes, I was there when this land was sold by Victoria to Awari, it is settled, the transaction is valid. But where it comes to registered title, just like we rent houses in different places and stay, the person who has a right of occupancy, who has a registered title, is a tenant of either the local government chairman or the governor,
Okay.
depending on the nature of the title you have. If it's a customary right of occupancy, you are a tenant of the local government chairman, and you have no right to sell that land without informing the local government chairman or without the consent of the local government chairman. On the other hand, if you are a holder of statutory right of occupancy granted by the governor of a state, you cannot sell it without the consent of the governor first sought and obtained. So where you want to sell a statutory right of occupancy, the term is assignment. So you have to acquire consent of the governor who granted to you to assign.
Okay.
Mind you, it's the office of the governor, not the person. So whether the governor is there or not, the one who gave you may have died, but the office of the governor remains. It is that office that granted the title. So you must seek and obtain the consent of the person who granted to you, because you are a tenant. But since it's a long term, it is a lease. So you have to get that consent. So you must obtain. In fact, if the consent is not obtained and you go ahead and sell, the sale is invalid.
Yes.
Wow.
You must have the consent. So, but what happens is that in most of the states, you have to get a form. They say application form for consent to assign. So you obtain that form and fill and submit and pay the prescribed fees. Once that is done, you have finished your own business. It is not for you to grant the consent or to refuse the consent. So once you have applied, you can go ahead and sell. Sometimes in preparing the documents of land transaction, it will be said subject to the consent of the governor.
Okay, sorry, just to cut you short from what you're saying. So it means that once I have applied, it is assumed that I will be granted.
Exactly.
Okay, so I can go ahead and do the transaction.
Yes.
Are there any instances where that application is refused?
Well, it is hardly refused.
Okay.
But there may be some situations where it may be refused. For instance, if the grant of the person was 100 feet by 100 feet or 900 square meters, and then he is selling 1,000 square meters, there's no how that kind of consent to be granted, because you are now attempting to sell more than what was given to you.
Okay.
So
and
consent cannot be.
What you don't
you
have.
cannot give what you don't have. So when it comes to statutory right of occupancy, the transaction has to be a deed. The agreement between the parties is not just an ordinary sale of land agreement.
Okay.
It is a deed of assignment, assigning your unexpired period, unexpired lease. The land was leased to you, was rented to you. Your rent has not expired. Maybe it was 99 years. You have exhausted 20 years.
Okay.
It's remaining 75 years. So the unexpired period, which is 75 years, is what you are going to sell, in quote, assign to the person who is buying from you.
Okay.
So that is what the governor will consent for you to assign.
Okay.
And so you must obtain that consent. And then the sale agreement, loosely called, has to be a deed of assignment. And that deed has to be prepared by a legal practitioner.
Okay.
So that's the world of difference between a non-registered title and a registered title.
Okay.
Just let me add, MEC, my friend has spoken so well, and I'm so glad about that. The other issue as to whether the consent could be refused, he's raised a very fundamental issue. But let me just add this way, that if the governor later discovers that the grant given to the person who is now seeking the consent of the governor to assign to a new person was obtained by fraud, is one ground
that he can refuse.
That the governor can refuse
Okay.
the application for assignment.
Okay.
Because it is expected that unless that consent is given, the person cannot alienate. By alienation, we mean transferring
Transfer.
his title to another person. So if he has obtained by fraud, then there is no way the governor will approve
exactly
the transfer to another person.
Okay.
So just to add to that.
Okay. So I'll just ask Barrister Awari, just continue from where he stopped. He raised an issue and say, you know, you will transfer the unexhausted time
Lease.
of your lease.
Yes.
You understand? So imagine that I have used up to 90 years
Yes.
of my lease,
Yes.
and I have only 9 years left. What is the fate of the person who is buying now? You know, because it's like, you know, I'm just buying the end part of, of the lease. And, you know, usually do people look at those details before they buy the land? Or you just find that, oh, somebody has land, he wants to sell, it has title, so it will be easy for me to just, you know, build up on that.
Yes.
Okay.
All right. That's very interesting. But permit me to use an African proverb that says that the soup of the bottom pot is sweeter. Well, that doesn't actually apply here.
Okay.
But the question is quite interesting one. If someone has already used up to 90 years, for instance, or even if he has used 98 years, leaving one more year,
Yes.
and what is the person who is acquiring getting? Actually, the law considers the fact that after the expiration of the 99 years,
Yes.
it is not that the governor will now come and start, taking over the land.
Okay.
He will not just ask you to vacate. But what the governor, through the land registry, which is usually from the Ministry of Land Survey and Town Planning, as Christine in many states, will do is to write the person who is in occupation now of the land
Okay.
to come for revalidation. A demand notice is usually given.
Okay.
The person who has had a term that has expired, the implication is that the land has reverted back
to the land,
to the governor.
Okay.
So the governor at that time in point is the owner of the land. So if you want to continue utilization of the land,
Okay.
you now apply to him for another term
Okay.
of 99 years.
Okay.
So the person who is buying at the tail end, if he takes the appropriate legal steps, will now have another 99 years unexhausted
Okay.
that will be given to him upon the expiration of the one that he has acquired from the former owner in court. Because the owner, like we said, is a governor holding trust for the people.
Okay.
So in that circumstance, if I now acquire, I use only 99 years from the previous owner, I will now apply to be given a fresh 99 years.
Okay.
So it's a continuous process.
Okay.
Yeah. So, but at every year, I'm expected as a good citizen to pay the ground rent.
Okay.
So we advise people that before you acquire any land that has a statutory right, or even if it's a customary right, ensure that the person you are buying from has paid his ground rate up to date. If you don't do that, even at the point of granting consent, when the governor sees that the person is in arrears of ground rate, the consent may be withheld.
Wow. Because
the person has not been performing his own part.
Okay.
So it is better the person you are buying from has paid his ground rents up to date. Otherwise, the application may be denied.
Okay.
So payment of ground rate is one issue that
is very
title
key.
Holders of right of occupancy or customary right of occupancy should pay. In some instances, you find out that the local governments don't even charge. But in some instances, they do.
Okay.
Especially in this generation of revenue
Generation of revenue.
internal government income are dwindling all over the world. There's a term that is used, economic meltdown. So government is looking for money from almost everything that was lying fallow. So they begin to say, look, pay from everywhere now. So demand notices are usually given from the land registries to holders of this title to pay as and when due.
Okay.
Let me add to this.
Okay.
That
sorry. While you're adding, I just want to ask so that you state everything together.
Okay.
He mentioned the issue of the fact that ground rent may be there's non-payment of ground rent may be a reason why the government may withhold consent. If, for instance, the government actually grants the consent and, the land is transferred, do I inherit the ground rent the previous owner in quotes was holding as the new owner? So I think you could just add to that.
Well, let me answer this first.
Okay.
Usually, at the time of application for consent, is a time to purge yourself of the wrongdoings of failure or default of payment of ground rent.
Okay.
Because the consent will not be granted if that ground rent is not paid.
Wow.
Normally, if you go to the Ministry of Lands of any state over transfer of title, they will usually look at the file and calculate the unpaid ground rent and give you demand notice for it.
Okay.
That is why it is good to conduct search before you acquire any land with registered title. Because what is meant by search is that you look at the file, you pay a prescribed fees and look at the file to see whether there is any encumbrance. For instance, Mr. A may have acquired a parcel of land and got a statutory right of occupancy.
Okay.
Then he approached a bank, maybe First Bank, and mortgaged that property, used that property as security for a loan, and took a loan of 5 million.
Okay.
And he has not paid that loan, and the loan has interest has accrued, and the loan is now 20 million naira.
Wow.
And he has not paid. If you buy that kind of land, it means you have that land is not your own until you pay 20 million naira to First Bank.
Wow.
So, but oftentimes people don't do this. They just see land, they say he's the owner, they have seen this, the COO, but the COO will not tell you what transpired after the grant of the COO. So it is always good to conduct a search. And sometimes if you look at the file, it may be confusing to you. So it is enough to use either a lawyer or a land expert that has the know-how that when he goes through a file, he will understand what it means, and then he will advise you appropriately. Now, on this issue of having a little time left before the land was sold or assigned to transferred to a new person, I had a very funny experience. You know, for us, we hardly look at these nitty-gritties. We may not even bother. For people who bought lands that are registered titles, if you call them and ask them, at the time you bought the land, how many years were remaining? They may not know. Many people don't even know that the land they bought has a specified number of years, after which it will have to be renewed. My experience was funny. I wanted to buy a particular brand of car in 2017. And then my sister said, how can you be buying a car that was manufactured in the year 2000? I laughed and said, sister, what you are saying is an Oyibo concept. It's an English concept. It's a Western concept. To us, how do you buy a car? You look at the car, you like the car. You now look at the car facially. You look at the outside, you say, wow, the car is clean. You open the engine and look at the engine is clean. You look at the interior of the car, it's clean. So you now start the car to hear the sound. You hear it sounding well, you say, fantastic, this is the car I will buy. And you move on. You buy the car and move on. I say, sister, for many people, if you ask them, what is the year of manufacture of your car? They don't know. So that is how we are. We don't care about some of those things.
Details.
But it is to our own detriment. There have been situations where people who launder money, took money outside of the country and bought properties that had a few years left to expire. When this expires, the thing reverts back to the government. You may say it is in principle, but the title is granted to you subject to right of, without prejudice to the right of reversion. So at the end, it reverts back to government. When you apply, the government may decide and say, application not approved, application not granted, and that ends it. And when you apply at that time, it is on the terms as may be given by the government. The government may decide to look at it and say, okay, now, because land is not just the ground, but anything on it.
That's true.
They may value even what you put on the land and say, this is the value of this land, so pay this percentage as a condition for grant of this same land to you. And you have no option than to pay. And then there are other situations. There was an issue involving Ekwa, that land that was granted to Ekwa pre-independence by the colonial government in Sokoto State became an issue to renew that grant, to get it granted to the government, or to extend the term, or to grant a new term. It became an issue. And so it can be, these laws will be in abeyance. So when you are not paying attention, you just look at land, you don't bother to know how many years are remaining that you are buying. You may be buying a problem. And laws are there in abeyance. The condition may be there as if it's nothing, that it may be granted to you on terms as may be granted by the government. That is in abeyance. But if they want to deal with you, they can dust it and bring it up, and you'll be in trouble.
Thank you very much. We will go on a short break. We'll be right back. You can, when we come back, you can make your calls and contributions. Thank you very much. Thank you, our viewers, for staying tuned. This is the Lifeline, and we've been discussing the topic land administration. So we will pick up from here. Barrister Zangawi, we've been talking about how to acquire C of O, and that's statutory rights of occupancy or customary rights of occupancy. We've also discussed the benefits of each of them. I want to ask, when you have, we will not shy away that there are actually disputes on issues of title of land, who owns which land, and all of that. So there are instances where you have to go to court on trying to prove this land belongs to me or this land belongs to you. Will you say a C of O, that's a statutory right of occupancy, or even that of a customary right of occupancy, is that a conclusive proof that I am the title owner of the land? Okay,
thank you very much, Victoria. A in the case of a dispute where there is two people contending, it will surprise you to find out that in some cases, you would find one land having two different RFOs or CFOs, as the case may be. There are such cases. On ground. But suffice it to say that legally, RFO will aid, or CFO will aid whoever is saying the land is my own. The presumption is that he had followed the due process to get the certificate as proof that the land is his own. But that presumption is a rebuttable presumption.
Okay.
It's rebuttable in law because there are instances that people have secured certificate of occupancy over land that they obtained them fraudulently.
Fraud.
So if there is a proof that the certificate was obtained by fraud, then it is not a conclusive proof that because I'm touting to have a certificate of occupancy over a particular piece of land does not confer legitimacy to that certificate of occupancy because it was obtained by fraud. Or if there was misrepresentation at the time of securing the certificate by the applicant, so that the Ministry of Lands and Survey, after careful analysis, could not dictate the misrepresentation by the applicant until a process has been completed. And it is now found out that there's a litigation and the person who is the holder now comes bringing it. Once it is proven that there was a misrepresentation to the to the ministry, to the issuing authority, which is the ministry or the local government, as it could be. So that title would not be a conclusive proof. Another instance is that if there is a mistake by both the Ministry of Lands and Survey and even the person applying, that is the applicant, there's a mistaken belief that the land belongs to him. And afterwards, it now shows that the land truly did not belong to him. That there was a mistake. Such title will not have overriding effect over the true owner of the land. So there are some of these circumstances that will vitiate the right or the propriety that will be, accorded to the land documents as called, that is customary right of occupancy or statutory right of occupancy. So in this situation, when you have misrepresentation, when you have fraud, when you have a mistake of fact from the applicant and from also the Ministry of Lands and Survey, the issuing authority, as the case could be, in the circumstances, that will not serve as a conclusive proof that because I have this document, it means. But suffice it to say that if my RFO or certificate of occupancy or customary certificate of occupancy that I have is genuine, it has no problem, then it could be used as a conclusive proof of title. Because one of the ways of proving title in a lawsuit is presentation of documents pertaining to the land that the owner is the owner. The person who is saying, I am the owner of the land, is showing that he is the owner, truly the owner of the land, by presentation of documents to the court.
Thank you very much. Do you have anything to add on that?
Yes, that one of the ways that we use to rebut the presumption of or the conclusiveness of a right of occupancy is that the person is not the owner, or he did not acquire from the owner. You know, we said earlier, last week we discussed how people could get land. It may be that they inherited with a gift or whatever, or they bought, or if they inherited, it is their land. But you find out that sometimes people who claim that a particular parcel of land is theirs is not their own. So if such a person proceeds to get a grant of right of occupancy, then that right of occupancy will be set aside if it is shown that the person was actually not the owner.
The original owner.
Yes.
Or the person who sold was not the owner. He just saw a parcel of land and then sold it. There are also situations of mischief that a person acquired a certain size of land and then on getting there realized that the land is so vast, and instead of taking 2 plots, he decided to take 4 plots and get grant of right of occupancy over the land. That will surely be set aside if it is shown that what he acquired was actually 2 plots and not 4 plots. But he went ahead to get a grant of right of occupancy over 4 plots. So these are in addition to what he had said. These are the other situations that could make rebuttal for the conclusiveness of a right of occupancy.
Okay. Thank you very much for this instance you just brought up, you know, of shifting the boundary lines. And, you know, even the Bible talks about not shifting the boundary lines. And this has caused a lot of problems within families, among community members. So it's important that you stay within what you have purchased and what you can purchase. Okay, Barrister Awari, we will quickly just, let's touch on this, the issue. What is resettlement of communities as it relates, or how does acquisition of land for public interests affect the original owners, you know, to resettle them and all of this?
Okay. The concept of resettlement of communities actually is founded on a situation where government acquires the land of the people who are living there on the land for overriding public interest. It's just like you have rightly pointed out. Assuming a hospital is going to be built or a university, you know, a university requires massive land.
That's true.
So the occupants or the owners of that land may be resettled by government in addition to compensating them from their original or from their ancestral land. They could be relocated or resettled by government.
Okay.
In such circumstances, what usually the government does is to say, okay, you are living, we are going to resettle you. That is, we are going to make you to settle in a different place other than your ancestral land or your original land or where you are living or customary land. We are going to resettle you to another land.
Okay.
So government shifts these people, government acquires the land and allocates it to the people so that they can have a place to live on. Because nobody will live anywhere other than on land.
That's true.
So, and then of course, they need land also for their agricultural purposes, because most of the people who are resettled, you'll find out that many of them are agrarian in nature. Their mainstay of the economy is agrarian in nature. So government will resettle them, bearing in mind the fact that these people are agrarian in nature. So they will have to resettle them in an area where they could find water and also find a place for the agricultural activities and livestock rearing and other things. But in most situations, what is expected of government to do if they resettle people is to also provide them with amenities in the new areas. But in most cases, you find that this don't happen because they have to, if you resettle a community, you have to provide them with schools, you have to provide them with hospitals, you have to provide them with roads, and make life better for them.
Water and light.
So water and light and health facilities and other things. This is expected of the government to do, in addition to paying them compensation.
Okay.
In some cases, it has happened, like people who were relocated in the FCT of Abuja. People were living in Garki before Garki became an urban center. They were resettled, those in Apo and other areas in Abuja. The FCT, Abuja, Nigeria, I'm using it as an example.
Yes.
So you could find that in also other African countries, maybe Ghana, in Accra, where the FCT was situated. You may find out that the people who were living there originally were resettled or they were compensated to leave. But I know that in Abuja, communities were resettled in some places other than where they were. And but there are a lot of complaints from the aboriginals of those areas. Some of them were built one room, a room and a parlor for a family man to go and stay.
Wow.
So it was not commensurate with where he was living. He was probably living in a better apartment, even if it was a hut. But he built his hut in such a comfortable nature that he could live in. But when the resettlement came, they just built makeshift houses for them. And then as the FCT continued to expand, these areas may be retaken again by government because they were resettled in some other rural areas. But I'm sure nowadays with modernization and expansion of the city, the people may be resettled again, or we don't know what the government will do in the future.
Okay. Barrister Ahile, do you have anything to add? And talking about this issue of resettlement, does it not imply that government should have foresight? Because if I have been resettled initially, and now you want to resettle me because of expansion and all of that, is that not lack of foresight from the government, considering the fact that, you knew that this is going to be the Federal Capital Territory?
Well, it would be very unfair if government would want to resettle people who were settled initially to carry out a second settlement, because it's been this, especially for Abuja, that the concept was conceived before it was executed. The city didn't grow over time like that. They decided FCT was going to move to this place, and they went there, and then acquired lands and revoked people's deemed customary rights, and then relocated them to certain places and built makeshift. Most of the houses are makeshift houses that were built for the people, and so those areas were designated as resettlement areas. They should remain. It would be unfair to come and disturb them again and move them from there to another place when it was initially in the plan that this is where they should be.
Okay.
Yeah, having said that, just to to add that where people are resettled, it is also unfair that government failed to provide adequate amenities for these people. Because oftentimes we find that the settlements are not conducive for provision of certain amenities. But where people are resettled, a town or a settlement or a village is now built. So government should, in fairness to these people, make life better for them, even if they were living in misery. At least that has disturbed their misery, so their life should be better. So if government will resettle people and then they are in a no different state from where they were, it's very unfair.
That's
but
true.
Let me say this, digression a little. I pass by the National Identity Management Commission office in Jos every day. And sometimes as early as 6 a.m., people are there waiting to be registered, to be captured for the national identity number registration. And one day I sat down and was wondering, if our government in Nigeria cannot register its citizens, then can we truly expect them to fix our roads and hospitals and schools and electricity and housing and all other needs. If registration that you just need a computer and a printer and your internet connectivity, and you can do it with a facility to take biometrics. If you cannot do that, then can we expect that this will happen? So when you now look at resettled people, it is not any different that government has failed. Ours is almost a failed state. So if they cannot resettle people who were disturbed and relocated from their ancestral homes, it is not any different from the failure of government.
Thank you very much, our discussants and our viewers. This is the much we can take today. But just to emphasize the fact that it is important that you register your land either with the customary either customary rights of occupancy or statutory rights of occupancy, because it has so many benefits for you. And the issue of shifting of boundaries, it's important that we do not do that, because it does not please God that we shift boundaries, and it affects the peace and even the relationship we have with our co-neighbors. Let's stay out of dispute. We'll meet you same time next week at the same time. Thank you very much. Have a blessed evening.